Hey, hi Tony.
Hey, hi.
Hey. How about the Earthball Road for the Lawati Mall?
Oh, you don't worry about it. Tan Sri told me he definitely will pay you. Don't worry about it.
But I want it to include the contract.
Oh yeah, don't worry. We will include it as a term in the contract. Come on.
Really?
Yeah, let's sign the agreement.
Okay. Hey Tony, where is my payment for the EBW? We have completed the work. 7 million, you know.
It's none of my business. It's the company.
How
None of
bad?
my business. I don't know.
How Tony denied to pay the 7 million for the EBW. 7 million, you know, such a huge amount.
Sir, we understand your concern.
But first, you have to know what's the doctrine of corporate personality.
A very good day, and I will start off the presentation with an introduction on what exactly is the doctrine of corporate personality. The company came into existence as an artificial person when it was incorporated, and upon its incorporation, the company will have its own legal personality, and this is distinct from its member as established in the landmark case of Salomon and Salomon. Under this doctrine, the company members and its company are deemed to be separated by the corporate will for the purposes of liability, property, capacity, and in relation to the acts done or the acquisition of rights. But nevertheless, there are still circumstances where the court will leave and pierce through the corporate will and impose personal liability on the members when it can be proven that the separate legal personality of the company is being abused. So this is decided in the English Supreme Court in Press and Petrodale Resources Limited has taken the opportunity to unify the doctrine of piercing through the will, and it continues to spark discussion within the legal field. And in Malaysia, this case has been determined by the Malaysian Several Court. Until the recent case of Ong Leong Chew, the applicability of press has been clearer as the Federal Court has considered the controversial principle of piercing the corporate will set out in press, beside disregarding the corporate will, and held Tony Ong, P.S. Bina, Perfect Solution jointly and severely on the basis on fraud liable, beside from the doctrine of piercing through the corporate will. And I shall pass the floor to my colleague, Tzu Chief, to elaborate more on this issue. Thank you.
To explain more on the doctrine, a company is deemed to have a corporate view separating the company and its members. The characteristic of a separate corporate personality can be seen in several circumstances. A company is entitled to own its property independently from its shareholders or members, as seen in Abdul Aziz's case, where changes in shareholders did not affect the company's ownership of assets. It also can enforce the insurable interest in its own assets, as illustrated in Markara case. So besides, the company alone is liable for its contracted obligation, and it can ever enter into contract with its own members. So in the aspect of related company, a holding company and its subsidiary were deemed separate legal entities, as seen in the case of People's Insurance Co. So the doctrine of corporate personality received its statutory recognition in Malaysia, which under the Section 20 Paragraph A of the Company Act 2016. As a separate legal entity, the company has a separate legal capacity as seen in Section 21 of Company Act 2016. Besides, a company has its perpetual succession independent from the changes of members until it deregistered. So the members also have limited liability towards the company. With the existence of the corporate view, it is not novel that the company has often been misused as a shell to protect the member from his or her own wrongdoing. In this situation, the corporate view will be lifted or pierced to hold the members personally liable for the wrongdoing made. After Salomon case, the courts in England started to recognize the exception to the separate corporation personality of a company where the corporate view could be lifted or pierced. Despite acknowledging the limited applicability of the doctrine of piercing the will of incorporation of the company, as other legal relationship will be first utilized in addressing the abuse of the company's separate legal entity. So the English Supreme Court in the Press case had marked a remarkable judgment by establishing the concealment and evasion principle. In Malaysia, the Federal Court in Ong Leong Chew case has affirmed the concealment and evasion principles held in the Press case, and the court further clarified the doctrine of piercing. Next on, I will be presenting on the facts of the Ong Leong Chew case. So, the dispute stemmed from the construction of a multi-story commercial development in Malaysia known as Melawati Mall. The Bina Peri, which is the main contractor for the project appointed by Sam Dabi, subcontracted the work to Perfect Selection, which in turn subcontracted the works to PS Bina, who again subcontracted to the plaintiff of this case, Killer Malaysia Sdn Bhd. Ong Leong Chew, also known as Tony Ong, was the director and majority shareholder of both Perfect Selection and PS Bina. The dispute arose when the payment of the empty bore works, which called as EBW, was reversed by PS Bina. The High Court held that there was fraud done by Tony Ong, as he made several misrepresentations regarding the assurance of the payment despite knowing that the main contractor would not pay for the EBW. Moreover, it was later found out that Tony Ong and the two other directors are no longer shareholders and the directors of PS Bina. In the High Court, Tony Ong PS Bina and Perfect Solution were held jointly and severally liable for the payment for the EBW by piercing the corporate bill. The Court of Appeal affirmed the decision of the High Court. The appellant appealed to the Federal Court. The Federal Court affirmed the High Court's determination of fraud, holding Tony, Perfect Solution, and PS Bina accountable. The court also supported Lord Danning's well-known principle that fraud unravels all, clarifying that court may disregard corporate personalities when the company is established for fraudulent purposes. I'll pass the presentation to my colleague to explain more on the application of the doctrine in this case.
Thank you, Zushi. Now, we'll look into the application of the doctrine of piercing the veil of incorporation in the case of Ong Leong Cho. In this case, the Federal Court did not fully apply the doctrine of piercing as the corporate views of Perfect Solution and PS Bina were disregarded on the basis of fraud. However, the court went a step further to explain the doctrine of piercing in press by applying Lord Sumption's principle. The Federal Court scrutinized the consumer evasion principle by Lord Sumption and held that it is not erred in law to apply the evasion principle in this case. By applying the consumer evasion principles to the facts, the court illustrated clearly how the principle can be considered by the court. In its application, it is relevant to take note that there are two companies controlled by Tony Ong involved in this case, namely Perfect Solution and PS Bina. For Perfect Solution, the court applied the consumer principle to discover the true facts of the transaction, and liability was later imposed based on the principal agent principle. On the other hand, the court invoked the evasion principle on PS Bina to pierce the corporate view. The key issue here was whether Tony Ong had an existing obligation linked to PS Bina. The court affirmed this by finding that Tony's fraudulent misrepresentation, which led to Keller to enter into the contract with PS Bina and complete the works. Tony owed an obligation to Keller which is linked to PS Bina. Thus, Keller had a legal right against Tony that is not of the company, and inserting PS Bina into the situation will obstruct Keller's ability to enforce those rights. The significance of this case is that the court has clearly stated the doctrine of piercing is to prevent the legal personality of a company from being abused by the controller of the company for wrongful purposes. This case has set out and clarified the application of the doctrine of piercing in Malaysia and illustrated in a clearer way how the consumer and evasion principles can be applied in our Malaysia jurisdiction. The consumer evasion principle was clarified in Ong Leong Cho much later after press. However, such a principle is consistent with Malaysian authorities as the case of Law Com Loy had drawn clear boundaries on when the corporate veil can be lifted, namely in circumstances involving actual fraud or equitable fraud. The latter arises when the corporate personality is misused to allow individuals to escape their contractual obligations or duties. This aligns with the evasion principle to pierce the corporate veil when there is a fraud by the controller of the company, making it straightforward to embrace this principle into Malaysian position in lifting the corporate veil. Now, I will pass the floor to my fellow colleague Kenneth.
The second issue in Ong Leong Cho's case is not very much relevant to press. However, it is still worth mentioning because it is one of the pertaining issues discussed in Ong Leong Cho, and it is extremely relevant to the doctrine of piercing the corporate personality. In this case, the appellants argued that the principle of the single economic unit test should only apply in the industrial court and not to leave the corporate view in commercial cases. To clarify the application and development of this test in Malaysia, the federal court in this case referenced the Court of Appeal's decision in Law Com Loy and Botek Sendirian Berhad. To determine the current position of this test, we have to look at the Federal Court's decision in Ong Leong Cho and Keller M. Sendirian Berhad, in which the Federal Court stated that the trial court relied on equitable fraud and fraud to lift the corporate view and not the single economic unit test. The Federal Court further clarified that the single economic unit test was only used to show that Tony Ong operated Perfect Solution and PS Bina as a single unit, making him their alter ego to establish fraud and to evade obligations. The court further differentiated between using the single economic unit test to disregard the corporate view and simply establishing if two companies were operating as one to detect fraud. In this case, the test was not solely used to pierce the veil, but to fact-find. It was further clarified also that the legal standards, including those for sham companies and fraud, are uniformly applied across all courts, correcting the misconception that the principles from Law Com Loy are only confined to the industrial court and not affirming their universal legal applicability. In a previous case in Ahmad Zahari Abdul Hamid and AIMS Cyberjaya Sendirian Berhad, the Federal Court held that for issues regarding employment law, the courts can leave the corporate view and regard group companies as one single economic unit. In this case, the relevant grounds that were used to leave the corporate view were grounds of injustice, unfairness, and group enterprise, which were two grounds. The current stance, as affirmed by Lawcom Lloyd, is that using the single economic test alone is insufficient to leave the corporate view. Ong Leong Chio's case demonstrated that this test can help ascertain the presence of fraud or equitable fraud, which are necessary grounds to disregard the corporate view. This test is primarily a factual tool and not a standalone basis to pierce the corporate view. Lawcom Lloyd's rulings remain valid and are applicable across all court levels.
Thank you, Kenneth, and I shall continue the presentation. So prior to the Gubachan case, it has been a long-standing situation where there are no standard guidelines for the court to actually leave or pierce through the corporate will. And after press, clearer guidelines regarding Malaysian position on the doctrine of piercing through the will were discussed in the case of Gubachan. And although such principle in press was not fully adopted in Gubachan, the federal court still examined the criteria for lifting a corporate will other than the reason of fraud alone, and concluding that it is permissible in three situations. First, if the corporate was established for the fraudulent purposes. Second, to evade an existing obligation, or when the corporate is established to prevent misuse of corporate personnel legal entity. This can open up room for Malaysian court to adopt the doctrine in a broader aspect. And the later case in Ong Leong Chio has taken a step further in clarifying prior ambiguities by recognizing and applying the principles set out in the case of press. Firstly, it affirmed the case of Gubachan where the corporate will may be disregarded when the company is used for fraudulent purposes, which assert the principle of fraud unravels all. This remained a valid legal principle and existing independently of the corporate will and the piercing through corporate will principle, which is discussed in the case of press. Secondly, the federal court further established Lord Sumption's approach by differentiating concealment and evasion doctrine and determine if will piercing is warranted in a case. It emphasizes the importance of first identifying the nature of the wrongdoing as either a sham or facade to apply the relevant principle in the case. So first, when the corporate structures are abused as mere facade, the concealment principle applies, allowing the court to look behind the facade without disregarding the corporate structure, or what we say the corporate separate legal identity. Here, will piercing does not occur. Instead, the court will determine concealed facts while retaining the corporate separate legal entity. Such an application is better in allowing the court to determine and analyze the basis on which liability should be imposed, rather than simply leave the corporate will without imposing liability on the party without any legal basis. And secondly, on the terms of sham, when a corporate structure is used as a sham, the evasion principle permits the court to disregard the corporate will if a company is used to exploit or to defeat an existing legal rights. Therefore, by holding individuals directly accountable, this principle actually narrows down the test of corporate personality, whereby there must be a legal right that exists before liability can be imposed. In the other word, the will ought not to be lightly pierced through or disregarded. Thus, the case in Ong Leong Chio has clarified the doctrine or the principle in a broader sense, whereby the corporate will can also be disregarded, even in a situation where fraud does not arise as long as it fulfills the condition under evasion. And I shall pass the floor to Genevieve for the evolution of cases involving fraud to pierce the will. Thank you.
Thank you, Vincent. I totally agree with what was discussed just now. On top of what was discussed by Vincent just now, I think it is also noteworthy to discuss that for cases involving fraud. So prior to Ong, the courts actually are more inclined to leave the corporate view when there is a fraud. However, after Ong, the court seems to be more cautious in piercing the veil, as the allocation of liability to the perpetrators of fraud now can be clearly done independently without the invocation of such doctrine, as fraud may vitiate all legal transactions directly. So this was followed by the case Ong Yu Leong and Mok Faizar, where liability was imposed on the defendants personally for the frauds committed. However, the positions of the fraud as one of the special circumstances where corporate view may be lifted are still acknowledged and valid, as can be seen in the case of Toyota Suho and Fuse One. And following Ong, the courts in BIB Vescori has also determined that
to disregard a corporate view, there must be evidence for fraudulent actions or an existing liability or obligations implying that evasion principle applies. Similarly, in the case D.Y. Quent and Ladang Sri Harapan, the Court of Appeal held that despite no fraud being involved, the corporate view could be pierced since the defendant had avoided their obligations to actually transfer the property held in trust for the plaintiff. So I think it can be said that Ong case has not only clarified the doctrine in press, but also expanded the options available to courts when there is wrongdoing in a company. Therefore, I think there is no doubt that Ong case actually introduced additional grounds in applying the principle by bringing in the principles of concealment and evasion, explain it clearly alongside with fraud. Lastly, I would like to give a brief analysis and conclusion based on everything we have discussed. So, the question of whether it is actually necessary to apply such doctrine often arises when discussing doctrine of piercing. While press was often criticized and commented in the UK, I think there was actually no confusion in Malaysia on the law of veil piercing, either prior to the adoption of press or either clarification of Ong was made. It can be said that Malaysian courts are rather flexible in applying such doctrine by actually allowing a variety of grounds for piercing the veil and allowing the concealment and evasion dichotomy to be applied for fraud or non-fraud cases. But in cases of obvious fraud, both principles could actually lead to similar outcomes, whereby making the distinction between fraud and evasion less impactful. Although the necessity of doctrine has been exposed by Lord Sumption underscores the importance of restraint in veil piercing cases by treating it as a last resort, I think the judges in press has indeed failed to actually provide a clearer explanation of the forms of corporate abuse that would justify piercing the corporate veil. By relegating veil piercing to a measure of last resort, I think this ambiguity could be interpreted as a judicial invitation for courts to actually exercise their own discretion in addressing corporate abuse in cases following press. So it was to be said that Ong had played a major role in clarifying both principles and applicability of both principles. Nevertheless, it is still important for local courts to always consider statutory provisions first, as it actually serve as effective mechanism to prevent parties from evading obligations owed to the third parties. Unsurprisingly, it can be seen that through subsequent developments, English courts are now more inclined towards not piercing the corporate veil. The same approach was actually taken by Malaysian courts, whereby, while allowing flexibility, are cautious in their application of veil piercing, as it is a must to first prove there is sufficient grounds of wrongdoing before simply lifting the veil. This was also emphasized by the courts in Ong Leong Chow. So, by introducing the principles of concealment and evasion, Ong added precision to the doctrine, providing courts with a structured framework to access cases involving fraudulent or evasive practices. To sum up, the court should always first consider alternative remedies, as the corporate veil should be the last to be lifted when there are no other legal remedies available. So the case Ong Leong Chow and Keller Sendirian Berhad, which we are discussing today, is undeniably a landmark cases in this area of law, as it not only clarified the application and applicability of doctrine of piercing the veil, but also further explained press principle in Malaysia.
Welcome to the Malaysian Legal Summit 2024 and welcome to this moderating session. I'm your moderator for today, and along with me we have key notable figures in the Malaysian legal industry. And today we'll be having an in-depth discussion and analysis on the Ong Leong Chow's case. So my first question is posed to you, Genevieve. Could you tell us about the Federal Court position in this current case, and what are their clarifications on the principles in this case?
Okay, so in Ong's case, actually, the Federal Court disregarded the corporate view on the independent ground that the fraud was actually proven, whereby it's also affirmed in the Gabachan case, which all of us know. Nevertheless, he still mentioned the concealment evasion principle in the sense that it actually illustrates to actually establish concealment and evasion principle, we need to have wrongdoing and we need to have fakat or shame to actually distinguish from each wrongdoing. And then it is very notable that in our High Court, the Tony Ong did not in fact in the law, to actually pierce the veil as one alternative introduced by press. However, the more appropriate way is definitely that has been decided in the federal court, whereby they use the principle fraud, unravel, or illegal bachan to actually bring out that fraud and the evasion concealment principle is actually not a same concept, but they can be existing together, and whereby in this case they are applying the fraud, unravel, or concept other than the evasion concealment principle. However, it was still not worthy to mention that this case actually cleared out the list of such confusion.
Thank you very much for that clear clarification. The second question we have today is posed to you, Ziqi. Could you tell us the federal court's rationale on holding why Tony Ong is liable?
Thank you for the questions. The rationale of the judgment for this case because due to happening the change of director, in this case which Tony Ong take the final step which resign as the director to avoid responsibility. So it makes the PS Bina as a company, as a defunct entity which incapable to pay the defendant. So this is unfair for the new director of the PS Bina, which is totally didn't involve in the fraudulent act. So we hereby agree with the federal court decision where to apply the Gubachan principle, which is more fairer to all parties to hold Tony Ong liable.
Thank you very much for the answer. The third question is directed to you, Vincent. Could you tell me how Tony Ong's case contributed to the legal development of company law in Malaysia?
So to address your question, I'm opining that the law in the case of Ong Leong Choo actually remarked an important milestone in the development of company law in Malaysia. Because it brings more flexible approach in Malaysia, like it set up a Gubachan principle and also applied to the press principle and says that now it is true that Malaysian court applied to two, and it depends on which one the court wants to apply. It depends on the situation and circumstances of the case. And in Malaysia, I'm opining that we have a better approach compared to the UK because like we are now having a flexible approach, as I mentioned in the Gubachan case, which is the principle of fraud unravels all, and also the principle in the press, the concealment and also evasion principle, which means that it is clear now the Malaysian court has developed into a more complete law in this area, because like in ascertaining fraud cases, it will be difficult for the court to just rely on one principle. So that's all from me.
Thank you for that. A good law is truly a law that brings fluidity. To wrap up today's session, I have a final question for you, Eva. Could you try to compare the current Malaysian position to UK's approach in press, and tell me what are the benefits or advantages that the Malaysian position has?
Sure, Kenneth. Compared to the UK position, where press can still receive criticism on the basis of its uncertainty, unnecessity, and unnecessarily, and therefore jeopardizing further development in the area of law, the Malaysian position is clearer on its applicability. We solved the issue of too rigid doctrinal principle in the press case. It's noteworthy that despite saying that press principle is applied in Malaysia, the court in the Ong Leong Choo's case has made it clear that the Malaysian approach is leaning towards our own principle that frauds unreveals all, because of its nature of flexible, and would not apply the press principle as arbitrarily, as its rigidity will possibly bring our position to the complexity as of UK and unsettled legal issue.
Thank you very much, and that marks it for today's session.